Well, thank you very much. And our last presenter in this panel is Boris Andrejaš from Boris Babić law firm. We thought it would be very useful to give a touch of Croatian flavor to this whole story. So we will be hearing a few words about the Croatian surroundings, environment of compliance.
Thank you all. But before I actually go into Croatian side of the story, I would like to touch upon the effectiveness of the compliance programs as part of the title of this session. I actually wanted to share with you the thoughts and doubts that I somehow gathered while preparing for this session, while reading about the compliance programs, their effects, the reasons behind them, and basically try to raise questions about do they work at all, and how do they work, and in which respect do they work. So I have tried to identify several reasons behind the implementation of compliance program. Some of them, well, actually most of them have been touched upon already, and to provide some critical standpoints regarding their existence. And these reasons behind compliance programs can be summarized in these several buzzwords which sound nice and actually can mean a lot of stuff. So we have prevention as the first step, then we have early detection as a second reason, then in the phase when hitting of the fan already occurred, we have mitigation of the fines or of the consequences of the violation, and finally on a level which is not completely connected just with the competition law or any substance of the compliance program, we have system integration within the company, better functioning of the company. So to start with the first one, with the reason which is here and which has like going forward outlook, and that is the prevention. One of the proclaimed goals of compliance program is certainly that they will prevent, or they will strive to prevent, violations of competition law or whatever other subject they're dealing with by the company and their employees. However, I have to say that while preparing for this, I have failed miserably in finding some statistical data, or at least some analysis which would show something like, look, in last 20 or 30 years we have boom of compliance programs, therefore the violations have fallen down or have not fallen down, the investigations have arisen and stuff. So basically when we are dealing with the prevention, I have not found any empirical data that would show that actually they are working in this respect, and we have heard why that can be so. It is not only because employees or addressees of the compliance programs tend sometimes to slip through the trainings on these issues, but also because you have some sort of maverick issue, one guy breaching the law and making you exposed to big fines that you cannot simply control, obviously. And the second of all, it is not only the compliance program, but again mentioned already, compliance culture, which will not only be focused on letter of compliance programs and compliance strategy, but also on setting the incentives within the company, because that is actually what is driving people to act in a certain way. That is actually what can drive people to disregard even the well-implemented or well-prepared compliance program and to go into something which can later on pose problems. The fact that, like as I said, I could not pinpoint the empirical data behind effectiveness of compliance programs with respect to prevention of antitrust violation doesn't mean that doesn't exist. Of course, that it doesn't work. It just means that I haven't seen it, but obviously it's not much. But it's certainly something that can be discussed, whether actually compliance program can prevent, or to which effect can it prevent violation of antitrust law. And anyway, we have all these cases which actually can prove us wrong. We have all these cases where companies with compliance programs have been found to violate the competition law provisions. The second, and I find this very important point, is early detection part of the story. Basically, in my opinion, effective compliance program would allow the company to find about the mischief before anybody else. And that not only is good because it shows that the compliance program works, but also because it opens a wide variety of possibilities that you can do. I mean, it will put you in front of the various choices, whether to burn the documents, as we heard, whether to pretend that nothing has happened, whether and when to run to the regulator, where to run, and why to run, actually, to save ourselves or to put somebody else in trouble. But the point of early detection is that it gives you time. Not necessarily that this time, this additional time will make your decision at the end better, but at least you will think about it a little bit more. And we have heard yesterday that this time frame between detection by the company and actions by the regulators, yesterday either Mark or Gabor mentioned 7 days in presentation, which is necessary for this internal audit to identify the risks and to make a basis for decision. If you prolong this time, it is obviously good for you and for the company. The third one is mitigating factor. Philip already mentioned something about that, and that comes into play when it is already too late for competition law because it has been breached. But now you are in a position before the regulator. They are discussing probably about the fines, and in various jurisdictions, various regulators will look differently into existence of compliance program. As Philip said, European Commission has said that, like, yeah, no, that was not mitigating factor. Even in paraffin case mentioned by one of the parties was claiming, look, we had a compliance program. Can you take that into account? Competition said something like, yeah, no, thank you. But anyway, it's not very effective competition compliance program if you are sitting here before us. Some other jurisdictions put emphasis on subsequent compliance. Companies have been found to be in breach. They say, look, we made a mistake, but from now on we will be better and we will act more in accordance with the law. So we have put this compliance program together, and for example, UK or OFT has regularly taken that into account when assessing the level of fines to be imposed. Also, in some jurisdictions, even this preceding compliance program can be taken account, but Canadians put again emphasis on effective compliance program. And then regulators tend to provide a checklist of things that should be incorporated into company's compliance program in order for compliance program to be viewed effective, even though the breach has obviously occurred. And I see a rather big peril in that approach, is that it incentivizes companies not to strive to develop, again, the compliance culture, but only to prepare a compliance program against the bullet points provided by the regulator. Actually, just like checking the box, and if something goes wrong, saying to the regulator, look, we have done everything in our power, we have done everything that you have requested from us. This guy is obviously out of control, so please take that into account. And emphasizing this mitigating factor of the story, actually, I think, puts into question all other benefits of genuine compliance program, because it will certainly not lead to the compliance culture if it is only on the paper. It will certainly not make company invest significant efforts which are necessary to implement and to maintain the compliance program. And on a more general level, I see with this mitigation of fines, I see some general fundamental flaw, or not, because Basically, it is rewarding the companies for obeying the law, saying, or rewarding them for trying to obey the law. And it reminds me of something that Croatian courts in criminal cases tend to cite as a mitigating factor in sentencing, is that, like, the defendant has not breached the law before, so we will decrease the fine for this, or the sentence for this crime, and I simply don't buy it. I am not saying that it is wrong, that it should not be done, that it doesn't have beneficial effects, but I also think that it has some deficiencies, and it has some defects which might affect the whole reasoning behind having compliance program. And the last one, which I have called system integration, and it doesn't necessarily have to do with something with the substance of the compliance program. Simply, the company functions as a system, as an organization. It needs rules, hierarchy. It needs corporate governance. If we are going to stick with the more legal terminology, and the compliance program, be it anti-bribery, anti-corruption compliance program, customs, competition compliance program. What it does, it introduces new set of rules, new set of procedures, new set of reporting requirements, and re-emphasizes the hierarchy and re-emphasizing the system of the company. So on a more general level, it can add another vitality to the system. It can help the system to react more quickly, even in the situation which are not necessarily covered by the substance of a particular compliance program. Of course, downside is that by putting too much rules into play, you might affect the flexibility of the action. You might prevent invention, or might prevent people to try to find some better ways of doing things.